Here in New York, a jury resumes deliberations in the insider trading trial of Zvi Goffer. Federal prosecutors have alleged that Goffer was the ringleader of an insider trading network that used prepaid phones and a fake paper trail to conceal their illicit trades. Goffer once worked for Raj Rajaratnam, who was convicted of insider trading last month. Joining us now, InsideTrack regular and our friend Doug Burns. He is a former federal prosecutor. He is now in private practice. Doug, thanks so much for joining us this morning. Zvi Goffer, his brother, another trader, all on trial in federal court in Manhattan today. Conspiracy, securities fraud. There's wiretapping. There's lawyers as witnesses. Is this Raj Rajaratnam Part 2, even though I want to make clear the cases are not related?
Well, it is sort of Part 2 because Zvi Goffer worked at Galleon at one point, Deirdre. But basically, you had attorneys at Ropes and Gray, okay, who were supposedly providing inside information about deals. And the sort of salacious part, as it were, are envelopes of cash, prepaid cell phones that you were supposed to, toss out when you're done using them. And those are honestly what you call badges of fraud, In other words, the argument being, why would somebody use a phone that you could throw out? Why would people be exchanging envelopes of cash? And then lastly, and most importantly, you also had wiretaps, just like you had in the Raj Rajaratnam case, which diffuses the idea that you can attack the cooperators by saying they're lying to save their skins if, in fact, it's on tape.
We know Galleon founder Raj Rajaratnam convicted, found guilty on all 14 counts. Right. We know his lawyers are going to appeal.
Yes.
What, if anything, does this mean for Zvi Goffer?
Well, first of all, Raj filed a motion, apparently I just caught this, to set aside the jury verdict. That's really done ordinarily in the course of events. He will appeal the conviction. I think the two cases are probably pretty much independent. In other words, as I explained in the past, an appeal, people get confused. They say, wow, he's appealing. He's claiming he didn't do the crime. That's not really what an appeal is. An appeal is, did the court, Judge Hallwell, make legal mistakes during the trial in Raj? So the two of them, to answer your question, are probably pretty much separate.
And we talked a lot during the Galleon, during the Raj Rajaratnam case, about just how much the judge actually, if anything, favored, or you can make the argument that he favored Raj Rajaratnam's defense.
Well, no question. Not only can you make the argument, but I submit that if you read the transcript of the trial, you're going to see lots of rulings that Judge Hallwell made that were pro-defense. A, because he's a fair judge, wanted to give him a fair trial. But B, when the dust settles from the fair trial, you end up in worse shape on appeal as a defense lawyer.
Another high-profile case, the former IMF head, Dominique Strauss-Kahn, formally going to deny charges that he sexually assaulted, tried to rape the maid from the hotel at a hearing today. This isn't a surprise, right? I mean, we've been hearing all along that he is going to plead not guilty.
Yeah, well, today's very straightforward. It's the arraignment on the formal charge, the indictment. Basically, they unseal it, okay, because it's been sealed. That's important for the media. Now we see exactly what the indictment says. They will waive a reading of it, of course, even though the media is going to have it. But defendants do that because they don't want it read out loud. Enter a plea of not guilty, which is a legal status, saying go ahead and prove it if you can. And then most importantly, you're going to get into discovery. In other words, the defense is going to be entitled to start getting the state's evidence. And that's when it's going to get really interesting, because you had said in the past, and you were right on the money, it's the forensic information, the scientific testing, the DNA, the potential blood, things like that. Those things generally don't lie.
Oh, lawyers for the alleged victim, I guess, are now preparing for the victim's character to be maligned.
Right.
How is this going to go? I mean, it was a woman living in the Bronx with her 15-year-old daughter. She's from Guinea. I mean, this seems a low blow, but I guess this is the way it's going to go.
Well, it is low blow, and you see it all the time. In other words, start trashing the victim. In the Kobe Bryant case, if you remember, they were trying to make sure that they could keep her identity as secret as possible so you wouldn't engage in all of this. One related corollary is I expect to see a civil lawsuit at some point filed by the victim against the defendant, for a civil wrong, a tort, as we call it, of assault and battery. And that's going to be interesting. I mean, obviously, it's unethical to use that as a wedge to make the criminal case go away. But by the same token, if there were a settlement reached in that case, Deirdre, and then all of a sudden the woman voluntarily decided to leave the jurisdiction of New York County, then things are going to get interesting because the prosecutors aren't going to have their case.
Chances are you're going to be back with us, Doug, to talk about that and go through some of the details. Thank you very much. Doug Burns joining us there, former federal prosecutor, a regular and friend of ours here on the the inside track. He now runs his own private practice.